All rise. Please be seated. Just going to wait for the photographer to finish. And in the meantime, I'm looking around and I'm asking now whether the people in the gallery can hear me properly. So that's the case. Ladies and gentlemen, good morning. On 30 March 2022, the defense finished its oral pleadings in the case of Pulatov, and the hearing in the case against the four defendants, Girkin, Dubinsky, Pulatov, and Kharchenko, was adjourned until today. The composition of the bench is the same, and the bench now resumes the hearing in these four cases. Present here today are Ms. Tenduschat and Mr. van Eyck, counsel of Mr. Pulatov, and once again I'll ask you whether you've been explicitly authorized. Yes, we are. You have been authorized, and that means that we'll be continuing the case against Mr. Pulatov as a defended case. And the court confirms that the relatives are present here today, as well as members of the Council for the Relatives, public prosecutors, representatives of the press, national representatives and international representatives, and there are some people from abroad as representatives. So welcome, ladies and gentlemen. The court confirms that the defendants Girkin, Dubinsky, and Kharchenko have not appeared. They are, however, informed of the hearing, and the cases against these three defendants will be continued in absentia. There is a simultaneous hearing in the cases of the four defendants, but the cases have not been joined. And the course of events of this hearing today is no different from previous hearing days. In the other rooms of the court building, there'll be a live stream, a broadcast of the hearing, and you can listen to the live stream both in Dutch and in English. And once again, you're not allowed to make any audio or video recordings during the hearing. Today, the Counsel for the Relatives, MH17, will be given the opportunity to respond to the public prosecution's address in all cases and the oral arguments of Pulatov. And the court will possibly interrupt the hearing for a short break, after which the public prosecution will take the floor in response to the oral arguments of the defense. And we have today, tomorrow, and the day after tomorrow available for that response. After this block of hearings, the defense will respond again, and that'll be as from Wednesday, 8 June 2022. And there'll be 3 days available for that response on the part of the defense. As we know, the case will then proceed to a stage in which the court will start to deliberate on a decision in this criminal case. And in view of the fact that the court will consider everything and anything that parties in the proceedings have put forward and have yet to put forward, the question is when the court will be able to pronounce its judgment in this criminal case. And you know that we have planned 3 possible dates for that, being 22 September, 17 November, and 15 December of this year. The court expects that the first date that I mentioned of 22nd September 2022 will not be feasible, which is why the court is informing you, taking into account the circumstance that people who are interested in the case and who reside abroad might want to travel to the Netherlands for the judgment, that 22 September 2022 in any case will not be a date in which we will be handing down a judgment. Since it is a formal day of hearing, there'll be a hearing on that date. But during the hearing, we expect to only inform the public at large that the hearing will be suspended or adjourned until 17 November 2022. At this point in time, we cannot with full certainty say whether the judgment will be handed down on 17 November 2022 or 15 December 2022. Since 30 March 2022, so after the previous hearing, the court received messages from the public prosecution in response to questions raised by the bench in the previous hearing block. And these are questions concerning, amongst other things, the structure of the indictment and only in the case of Gherkin, a question about seizure. The messages the court has received will also be addressed by the public prosecution in this block of hearing. And furthermore, a number of documents have been received to further substantiate the claims that have been submitted for compensation. They were also received last Friday, and insofar as we have not done so, the court will incorporate all these documents in the files of the defendants. Counsel for the relatives, in a letter of 5 May 2022, requested the court to lift the restrictions on allowing relatives to have access to the criminal file or the restrictions concerning providing relatives with copies of these documents. According to Counsel of the Relatives, these restrictions have always been at odds with the circumstance that the right to access documents to the proceedings is a right of the victim, and in this case, the relatives of the victim. And the criminal proceedings are now in the end phase, and documents of the proceedings have been discussed in detail, and in this phase there are no further witness examinations or any other investigations. The public prosecution, prior to the hearing, has let us know that it agrees with the request to lift these restrictions, and the defense also informed the court by means of a letter not to agree with the request to lift these restrictions. According to the defense, it hasn't become clear why the documents submitted by the defense in its oral arguments would be documents that would be of interest to the victims. And should that be the case, then access to certain documents, such as the video of their client, the letter of the American experts with names of those experts, as well as the names of other experts who have been consulted, could be incompatible with the interests of these persons, because by taking cognizance of this information, these persons could experience grave inconvenience in performing their official position or their profession. And finally, the defense highlighted the risk of swaying witnesses and/or experts. In view of these diverging positions, the court requested counsel for the relatives to explain their request to lift the restrictions in further detail today. And possibly the defense and public prosecution can then subsequently also take the floor on this matter. After that, the hearing will be continued as planned, which means that now I shall give the floor to the counsel for the relatives in order to explain their position and their request.
Yes, thank you. Your Honor, thank you. We have drafted notes in order to explain that request, and it's also meant for the clerks to be able to keep up with what we say. Your Honor, Your Honors, public prosecutors, defense, relatives and all other people that are present. Upon the start of these criminal proceedings 2 years ago in March 2020, the defense for the relative of the counsel for the relatives requested you to provide a copy of the procedural documents. During the hearing of the 10th of March 2020, the Public Prosecution Service objected to that. The risk that these documents, before they would have been discussed at the hearing, would be made public was a compelling argument for the Public Prosecutor Service to limit the rights that the relatives have to have a copy of the case file. And the defense, who were also consulted about the request of the Counsel for the Relatives, stated during the hearing of the 10th of March that they did not feel the need to reply. On the 23rd of March 2020, your court decided that a too generous provision of procedural documents might impede any investigation that need yet to be performed, and the risk that disclosure of these procedural documents might have an impact on any witnesses yet to be heard was deemed too large. For that reason, your court provided a part of the procedure documents to the members of the Counsel for the Relatives and then imposed a restricting condition that these that these documents could be discussed with their clients, but that inspection documents with the clients was not allowed. In all later decisions with regard to adding to the procedure documents, you have indeed maintained that condition. Now that the criminal proceedings are currently in the final phase and a lot of details have already been discussed at the hearing in detail, and no witnesses can be heard in this stage anymore, or other investigations will not take place. Therefore, the considerations on which the limitations were based in 2020 can no longer support the upholding this limitation 2 years later, also in view of the grounds for refusal as referred to in Article 187 of the Dutch Code of Criminal Procedure. No more. In addition, and the chair said that the restriction has always been at odds with the fact that relatives themselves are entitled to consult procedural documents and not just their counsel or their representatives. Now, and this is why the Council for the Relatives has recently requested you in a letter to determine that these restrictions that were imposed will be lifted immediately or alternatively on a date at the court's discretion. Now, in response to our request, the PPS stated that the risks that were the grounds for the restrictions in 2020 to limit the rights of the relatives no longer exist now. And the Public Prosecution Service indeed put some more detail to that last Friday. In June and November 2021, the file of the case was fully discussed at the proceedings on the merits, and the risk that early disclosure of the details would have an impact on any witnesses to be heard no longer exists. This is why the PPS holds that there are no grounds anymore to maintain the restrictions by which the case file was provided to the Council for the Relatives, and therefore the PPS agreed to the fact that these limitations, these restrictions be lifted, also with the document that was added on Friday. Now, however, the defense does not agree, and in a letter of the 10th of May, they objected to lifting these restrictions, and for various reasons they cannot accept that, and I will elaborate on it. But first, I want to address the matter whether the defense should be allowed at all to object now at this stage of the proceedings against the request of the Council for the Relatives, and that is because the defense stated at the hearing of the 10th of March 2020 that they did not feel the need to respond to the request of the Council for the Relatives to provide them with a copy of the procedural documents. The defense, as the Council for the Relatives has assessed, did not use its opportunity at the time to object to provision of documents to the relatives. And therefore, the current objection with regard to the request for lifting these restrictions is too late. Now, the opportunity to object was not, they did not avail of their opportunity to object, and the defense that they make now can therefore be ignored. Now, even if your court holds that it must consider on substance the objections of the defense counsel, then it applies that they cannot succeed. First of all, the defense takes the opportunity
that these documents are not procedural documents that are important or interesting for the relatives. And this notion is incorrect. In March 2020, we already stressed the importance of these documents, of having access to these documents in order to be able to deal with the grief. And there's something else, and also the fact that the relatives are a party to the proceedings. Article 6 of ECHR requires equality of arms for all parties in the proceedings. When the public prosecution, the court and the defense have access to a file, then the relatives also have to have access, and limiting their access to the file would be at odds with fundamental human rights. I'd like to refer to case law of the European Court that are included in my pleading notes. And second, the following is relevant with respect to the interest that the relatives have with respect to access to the case file, and that is the importance of fact-finding, because an important purpose of this proceedings is fact-finding, and that is one of the interests that the relatives have in this proceedings. The documents of the proceedings, along with the hearing itself, constitute the primary sources to answer the questions that have been posed in Article 348 and 350 of the Code of Criminal Proceedings. And many relatives have been waiting for those questions to be answered for many years and are waiting for the judgment of the court. And a question that arises in this connection is how the judgment can contribute to this feeling of justice among the relatives if they're deprived of the information that forms the basis of such a judgment. If the relatives cannot have access to all the sources that the court has had access to in order to hand down judgment. If that is the case, not only the access to and understanding of the judgment will be jeopardized, but also sheds a different light on the impartiality and the authoritativeness of a judgment, and also the interest that the relatives have in being able to rely on the administration of justice. For that also, it's important to have access to documents of the proceedings. And during the impact statements, many have talked about the implications and the impact of disinformation that has been spread over the past few years. The fear that this disinformation may influence the proceedings is felt when we talk to the relatives. In order to dispel any doubts about the sources that constitute the basis for the judgment of your court, it is important that the relatives have access to these documents. Access to the documents of the proceedings not only offers us the possibility to apply checks and balances and also to have faith in the independence of the legal system, also to dispel any feelings of fear, uncertainty, and suspicion. But these feelings will be rekindled if it remains impossible to access the documents that constitute the foundation of your decision. And that is precisely the interest that the relatives have to be able to access all documents of the proceedings. So this with respect to the interest the relatives have in having access to these documents. And now I would like to comment on the fact that the grounds to deny such access do not exist with respect to Article 187D of the Code of Criminal Proceedings. Insofar as the defense is trying to protect the interests of their own client, we would like to note that his interests are not mentioned in the article that is referred to by the defense. Article 187D, Section 1A, only concerns the fear that a witness would experience serious inconvenience in the event of disclosure. This article does not concern the interests of the defendant. Furthermore, the article requires that the inconvenience to be expected must be serious. And in that respect, we must highlight that the defense itself decided to show the video statements of the defendant during the public hearings that were broadcast across the world with a live stream. The video statements, therefore, were made public by the defense itself, and apparently the alleged risk for serious inconvenience did not keep the defense at the time from disclosing the images themselves. So it would be incorrect to use this argument to deprive the relatives of access to these documents.
To the extent that the defense in invoking Article 187D of the Dutch Code of Criminal Proceeding means to protect the interest of witnesses and experts, we feel that they should also feel that, first of all, because the defense doesn't sufficiently substantiate on what that expectation of a serious inconvenience has been based. Many experts over the past few years, based on their expertise, spoke in public about what happened on the 17th of July 2014. So why the experts cited by the defense should remain anonymous, where others have gone public, is simply not clear. The fear of a serious inconvenience therefore seems unfounded. As to the interest of the relatives in the names of institutes and experts responsible for the report submitted by the defense becoming known, I simply refer to what I've just said about the interest of the relatives in access to all sources that the court uses for its judgment. The relative counsel feels it is of great importance that the relatives aren't just given the opportunity to inspect the contents of these reports, but also the information to do with their authors. Only then will the relatives be able to arrive at an independent opinion about the weight to be attached to the conclusions of these experts. And the defense finally points to the risk of witnesses still to be interviewed being influenced, and we take the defense to be referring to the compelling interest of the investigation described in Article 187d, paragraph 1 under B of the Dutch Code of Criminal Procedure. But this must also fail. That compelling interest of the investigation in this article is a much more severe criterion than the simple interest of the investigation. The arrangement of Article 187d does not regard documents that cannot be released in the current criminal procedure because it would impede the investigation, but in the end cannot be withheld from the defendant. In Article 187d, it is about data that are expected to never be known, not during or after the hearing in court either. For example, that's data to do with informers or the concrete implementation of specific investigative methods, strategies and techniques. It is in the public's interest that such data can be kept from the public. The criminal file in this case does not qualify as such because the case file has been discussed in public by now. And the relatives also, in their capacity of injured party, are party to these proceedings. And as I said before, Article 6 of the European Convention of Human Rights requires equality of arms for all parties to the proceedings. And to now, at the end of the hearing, withholding documents from a party to the proceedings with the argument that maybe during an appeal witnesses might still be interviewed would go against all the principles of a due process. And with regards to the documents recently submitted by the defense, we can say the following. Some of these documents are already public. They can simply be consulted online, and I refer you to where you can find them. And also they've been attached as attachments to the record of the hearing. Defense finally didn't respond to the argument asserted by us that it is not inconceivable that in the near future third parties might make requests. For example, relatives not represented in these proceedings might request inspection or copies of certain procedural documents, and that the assessment framework, which we can find in the Judicial Data and Criminal Records Act, there is no room to refuse them access to those documents, and in that case you would get the situation that third parties might get access to certain documents, but the relatives represented in these proceedings will not have access. So we persist in our request of the 5th of May 2022. We asked the court to end the restrictions that were imposed on the 23rd of March 2020. And I'd like to add one more thing that is not in my pleading notes, and that is the suggestion that we made in a letter of the 5th of May, which is to use Article 28 of the DCCP, which is the prohibition to disclose that can be imposed on parties, to not disclose certain documents. And if the court would like to use that article, we would ask it to not include the entire case file in that, because I cannot exclude that we might use parts of the case file in other proceedings, that we will need those documents, and that it would be very awkward if Article 28 applied to the entire case file. But if the court does apply Article 28, we would like it to apply only to specific documents or parts of specific documents in the file. Thank you very much for your attention. Thank you.
Thank you. In my introduction, I pointed out that the court, the defense and public prosecution, would have the opportunity to respond. I'm just looking at both of you to see whether you would like to respond immediately. Okay, first I'll give the floor to the prosecution. You have already responded, and then you had an additional response, but you did not refer to this last aspect. I'd like to give the floor to the prosecutor. Thank you, President of the Court. Public prosecutor, along with counsel of the relatives, that access to the documents of the proceedings in this stage is in the interest, and I'm referring to case law here, is in the interest of the relatives. First and foremost, in the interest of the remaining hearing with respect to the claims of compensation of injured parties, and second, in the interest of processing grief and coming to terms, and third, also in the interest, as counsel of the relative just put forward, in the interest of their faith in the administration of justice. Your court, in June and November last year, discussed the entire case file, and therefore the prosecution is of the opinion that there's no longer a ground to uphold the restrictions as imposed to the counsel for the relatives earlier on. There's one nuance that we would like to put forward in this connection. Nuance that has to do with a number of documents of the proceedings and parts thereof. Because we see insufficient interest of the relatives, referring to this article of the Code of Criminal Proceedings, to have access to the official records of the hearings, because that can be checked on the website of your court. Nor do we see sufficient interest of the relatives to have access to the names of M58, the witness, and also the expert that has been discussed under our C number here at the hearing. And based on Article 51B of Code of Criminal Proceedings, and in line with the decision of your court of the 1st of March 2022, the identity of these persons must be redacted beforehand and protected. With respect to the status of the list provided by the defense of the American rapporteurs, it is not entirely clear to us at this stage whether this information has already been incorporated to the case file by the bench, and insofar as this has been done or shall be done, we see insufficient interest of the relatives in this respect to have access to these names. But later on we'll be discussing this in greater detail in our reply. So no copy would have to be provided pursuant to Article 51B. And our assessment takes place with respect to this provision. Article 28 does not have to be applied here because the interest of providing documents are not limited to the claims of the injured parties, and so are limited to the civil proceedings within this criminal proceedings. And for the rest, copies can be provided of documents, procedural documents, insofar as individual relatives have requested as much. Thank you. Says the President of the Court. Mr. Ndusrata. Thank you. Thank you. So my microphone is on. Everybody can hear me. Thank you. Ladies and gentlemen, prosecution, counsel for the relatives, letter of 10 May, I'm referring to that. We have put forward, and for that reason, it was not tardy, we put forward our position with respect to the request that was made briefly before that. This is a response to a request of a couple of weeks ago So you can hardly call this tardy, too late. So, but in my observations, I'll refer to that, but I will also highlight a couple of points following up on what was said just now. Primarily, our position is that not all procedural documents are documents in the sense of 51B. Not all documents are documents of proceedings that require access. On behalf of the Council for the Relatives, it has just been explained why the relatives, in general, for several reasons, would have an interest in having access. And the prosecution has just summarized this, and that, in general, there could be an interest to have access. It's not something we deny, nor do we dispute that. We are focusing on specific documents of the proceedings of which we say that the interest in having access to those documents not become apparent. And with respect to these specific documents of proceedings, and I don't know exactly where they've been mentioned in this letter of 10 May on the top of my head, I think it's the annex to the pleading notes. I haven't heard why there should or would be an interest to have access. And for those annexes, the substance thereof has been discussed during the hearing. In any case, in a summarized way, they were either discussed or shown. And the fact that nonetheless there would be an interest to have access to these underlying documents is something we fail to understand, and I haven't really heard anything to the contrary. Should your court reach a different opinion, should your court find that there is an interest to have access to these documents, then the question arises whether there is a reason to deprive the relatives of such access at this stage. And we believe that that is the case, and this has to do with the interest in 187D. The Council for the Relatives say that those interests are not applicable to a suspect because this article refers to the witness for whom these interests come into play. This is, however, incorrect. It's not about Article 187D, but in 51B, there's reference to the interests that Article 187D is refers to, and these interests is experiencing serious nuisance or impediments in performing a profession or an official position, and those interests are not limited to certain groups of people, could also apply to experts. So it's not about 187D, it's about the interests. And of course, everybody has these interests. Our client has these interests as well, and our client has been focused on, and we've seen his name and his images, and the fact that a video has been shown of our client, that doesn't mean that we can never invoke other interests. First it was about other videos, but at the time it was about a video which we deliberately decided to show it. And now we're talking about other videos and other circumstances as well. For every video, and this is what for every video, we assessed the video and decided whether or not the video would be eligible for disclosure at the hearing. And for these videos, the outcome was that they should not be shown. And as I said, the contents has been discussed and they've been added as an annex. And the world has changed quite substantially since us showing the first video and the videos that we're talking about now, and the situation that we are in right now. In this situation, the risk for serious inconvenience for our client, we considered this risk so substantial that we didn't feel it was responsible to show that here at the hearing. Furthermore, imagine our client would have been in the position to attend the hearing. What if he would have appeared here and would have made a statement? Then the press directive would have stipulated that his image cannot be shown just like that. So the fact that he is not here, but we showed a video, does not change that. And so we see that there are serious objections. We don't want his image to be shown in an unlimited way on the internet. For the experts, in terms of the experts, I would like to say, unlike the Council for the Relatives that put forward, the Council of the Relatives says why would the expert put forward should be anonymous, whereas others, their names have been disclosed. But the experts that we requested to make a statement explicitly requested and made it a condition that their names would not be disclosed. So that was a decision for them, and they wouldn't have reported if their names would have been disclosed. And we agreed this with them, and I think quite rightly so. And furthermore, other experts have not been disclosed, and there are very many, and this is why we have always spoken about the experts from that institute or expert RC number such and such. There are very many reasons for experts, many experts, to want to remain anonymous. Not only our experts, but there are other experts as well. A reason was that someone said that he or she had experienced a serious inconvenience, and that is why we all agreed that we would proceed in a way that we would not disclose the names. So just as this applies to the other experts, it also applies to the experts that we consulted. Let me see, and then in conclusion, this last reason, swaying or influencing witnesses, this has been explained in a letter, and I'd like to refer to our letter in that respect. I'd like to just emphasize that, no, it says the Council for the Relatives interprets our letter in such a way that we would be referring to 187D. That's not what we're saying in the letter. We just referred to the risk of swaying witnesses or experts, and we point out that the risk, as far as we're concerned, it still exists, because we cannot rule out that even after this, in these proceedings, experts or witnesses could be interviewed in other instances, and the fact that the file has been discussed, that with all due respect for the level of detail, is particularly an important fact, because the most important matters have been discussed at the hearing, first by the bench, and then the public prosecution's address, the oral arguments, reply and rejoinder. A lot of matters have been discussed, so therefore having access to the underlying documents is no longer an interest for the relatives. But the interest of swaying, if you'd know all the details, and all the details would be disclosed, it would still be a substantial risk. So we persist, in short, in what we highlighted earlier on in this respect. Thank you. Question is whether that gives rise to a comment on the part of Counsel for the Relatives. No, I don't think so. We persist in our position. The only thing I would like to highlight is that even the Counsel of the Relatives doesn't have access to the list of experts that has been consulted by the defense. I just wanted to highlight that. President of the Court, I'm just looking at my colleagues to see whether we have any questions. No, I don't think so. Okay, the court will deliberate on this point, and as soon as we take a decision, you will be informed, and if possible, we shall do so during this block of hearings. So, okay, this brings us to the reply as planned, and for the reply proper, I'd like to give the floor to the Counsel for the Relatives. Thank you, Your Honours, ladies and gentlemen. In this phase of the criminal proceedings, we will use this reply for what a reply is meant for, namely a reply to what the prosecution has put forward in its prosecution's address and what the defense put forward with respect to the claims for compensation in its oral arguments. So I will not be discussing all relevant topics for the assessment of the claims of the injured party, which means that I shall not discuss the jurisdiction of the court. I shall not discuss access to criminal proceedings as referred to in Article 51F, the applicability of Ukrainian civil law, the several liability of defendants, the circumstance that there's no set-off of insurance payments and payments by Malaysia Airlines, the question with respect to subrogation and recourse, accumulation of compensation for damages for relatives that have lost several relatives, and compensation measures. Now, all these topics have already been discussed in depth in the written exchange, and we would like to highlight that we persist all our positions that we've taken so far. So it's unnecessary to discuss the details of these topics because the prosecution agrees with the views of the counsel for the relatives, and the defense of Pulatov has not taken a substantive position with respect to these topics. And the written exchange of documents between the public prosecution and counsel for the relatives has led to the fact that the difference in views about the claims has been reduced to one point, being the level of the compensation. And the prosecution is of the opinion that the claims can be granted, but for a lower amount than was claimed. And the amount of compensation, therefore, is on the agenda for this reply. In this reply, I shall not discuss the indictment and the debate about this notion of functional perpetration, although we could say a lot about this topic also from a perspective of civil law, and in my footnote I've included some references to literature in that respect. In this reply, however, I shall discuss what the defense of Mr. Pulatov put forward with respect to claims for compensation. No defense has been put forward against the level of compensation. Quite the contrary, the level of compensation has been, or the scope of compensation has been fully embraced by Mr. Pulatov, albeit that he says that he is not the person who should bear the compensation personally. And I'm quoting from the oral arguments of the defense. No punishment is too great with respect to the indescribable severity of the consequences, and these same consequences would justify or could justify any compensation. But our client is not the one you should turn to, is what the defense said. The claims themselves have not been disputed substantively, nor have the facts been disputed that concern the existence and the scope of the damages. And to be complete, I'd like to highlight that the other defendants have not put forward any defense whatsoever either against the claims for compensation. And this brings me to the second topic of this reply, and that is the consequences that not disputing these claims in view of Article 149 and 150 of the Code of Civil Procedure would have for the assessment by the court of the claims for compensation. But first of all, I shall discuss the admissibility of the relatives' claims. Following up on the defense put forward by Mr. Pulatov that an assessment of these claims would put a disproportionate burden on the criminal procedure. The fact that this defense should be dismissed is something that we have stated repeatedly, and we have substantiated our positions. The Counsel for the Relative refers to its explanations in writing and its oral explanations, and would request you to incorporate those positions or consider them incorporated in this reply. And since it's the only point that Pulatov's defense put forward in this respect, I have to discuss the substantive matters. But I try to find a new perspective to discuss this topic, and that is the legal theoretical perspective that compensation should be considered to be an essential part of a settlement by a criminal court. Reparation of suffering in the form of compensation as an independent objective of criminal law. I'll be discussing this in detail at the very end of the section about admissibility. And so, summarizing in my reply, I shall be discussing 3 points: the admissibility of the claims of the relative and what not disputing these claims means, in the light of the law, Article 149, and the level and scope of the compensation. First of all, I shall discuss admissibility. Pulato's defense against the claims is limited to the position that the relatives' claims are not admissible because a substantive assessment that in these criminal proceedings would be too much of a burden. This is Article 361, Section 3 of criminal proceedings, and the fact that other requirements, such as the requirement of direct damage, has not been disputed by Pulatov, and also the fact that relatives have access to the criminal proceedings. That has not been contested. It's important because there was reference to expertise concerning Ukrainian law, which is what parties to the proceedings do not have. And if the defense refers to counsel of the injured parties in terms of a party to the proceedings, that's incorrect, because the lawyers of the counsel for the relatives have sought expertise about the system of Ukrainian civil law and cannot be considered to be lay persons concerning Ukrainian law. The defense, to substantiate this position, referred to the complexity and exceptional nature of the questions that are relevant in connection with these claims. And we can immediately admit to the defense that a number of questions that are to be assessed in these criminal proceedings are indeed complex, and that not only applies to the criminal law questions, but also civil law questions. We can also readily admit that a number of the questions that concerning the claim are exceptional by nature, in the sense that these are not questions that are dealt with in an ordinary criminal proceedings. But the simple fact that a question is complex or has an exceptional nature does not mean that the assessment of the claim in a criminal proceedings for that reason alone should be set aside. So the legal criterion is whether the assessment represents and constitutes a disproportionate burden in the criminal proceedings, and furthermore, the questions to be put forward that from time to time would be complex or have an exceptional nature should be assessed against the background of this very encompassing and exceptional proceedings. Whether there is a disproportionate burden for the criminal proceedings is assessed on the basis of the proportion, the balance between the complexity of the criminal case and the civil claims. And the more complex a criminal case is, a proportionate additional burden of the civil claim may not lead to the fact that the Dutch criminal court does not hear these claims. Proportionality is a key concept. Needless to say that this proceedings from a criminal law point of view is complex, and also in a quantitative, from a quantitative perspective, this is a comprehensive proceedings. There have been 61 hearing days. 9 hearing days, some time was spent on the joinder application. So that's 15%. In actual speaking time, it's much less. And in that respect, hearing the claim cannot be deemed to be disproportionate. And furthermore, the claims, given the uniform nature of the claims, and also because we decided to claim damages for pain and suffering and not for material damages, as the damages are clear-cut and relatively straightforward. And it's not a problem that foreign law needs to be involved. There are several examples in case law in which claims have been assessed under foreign law, and these were cases of Ethiopian and Rwandan law, jurisdictions that perhaps are how should I say it, that the possibility to understand those systems is maybe more complicated than Ukrainian law, and Ukrainian law is based on the basics of our Dutch civil code, so perhaps easier to understand. And your court has already considered that the applicability of foreign law need not be an impediment for the admissibility of the claims of the relatives. And this preliminary view coincides with what the minister specifically said about the criminal trial for MH17 in its letter of 7 January 2019. The Minister of Justice considered, and I'm quoting, that the possible application of foreign law in this case, as such, is not a reason to consider the claims to be a disproportionate burden to the criminal proceedings or to declare those claims to be inadmissible or to refer the case to a civil court.
And I now address the question whether how we need to assess this admissibility case in the context of Article 6 of the ECHR, because we understand the defense of the Pilatus Council that they wanted to frame the defense in the framework of ECHR Article 6 and mean to say that they could not or put up a defense or insufficiently because of the complexity and the exceptional nature of the outstanding questions in combination with their lack of expertise in civil law, and that defense does not succeed, and there are several reasons for that. Now, first of all, the Dutch Supreme Court, in its clarification ruling, linked the possibility of non-admissibility due to insufficient opportunity to put up a defense to a situation in which the limitations of the criminal proceedings ensured that there was insufficient option to defend itself. Now, the Supreme Court intends in saying so that in the context of criminal proceedings following Article 334 of the Dutch Code of Criminal Proceedings, only limited provision of evidence is possible because the defendant and the injured parties cannot contribute witnesses or experts with regards to the claim for damages. However, that limitation is marginal because the same article does not affect that the witness statements and expert reports are submitted by the parties. However, the fact that they cannot hear witnesses or experts is not the reason argued by the defense for inadmissibility. The reason is much more principle in nature and relates to the fact that they believe that it cannot be expected from Dutch counsel in Dutch criminal proceedings that they consider a civil claim to which foreign civil law applies. Now, in doing so, they fail to recognize the case law that we mentioned, from which it entails that the applicability of foreign law need not prevent the admissibility of the claims of the relatives, and they fail to recognize the special character of these criminal proceedings that pertains to trying a case committed in an international context. And that international context does not only affect the criminal law questions, but also may entail that civil claims adapt to the shade of a foreign legal system. A criminal defense counsel in such proceedings can indeed be expected to put up a defense or find answers to any questions relating to the claim, even if these questions pertain to several jurisdictions. And that it often happens that criminal defense counsel requests assistance of a civil law counsel or an expert in Dutch criminal proceedings has happened quite often, and nothing, and Pilatus counsel was not barred in these proceedings to do the same. And they could have, as the counsel for the relatives did, request assistance from a Ukrainian professor or a counsel, and could have submitted an expert report. The fact that they did not do so and did not put up a defense for that reason against the claims is at their own discretion. It has nothing to do with limitations of the criminal proceedings, as the Supreme Council indeed intended in its clarification ruling. Now, the defense by the defense that they were not able to put up a defense doesn't qualify for other reasons, because the claims for damages are substantiated so much that Ukrainian law has been made clear sufficiently and in a sufficiently expert manner. Together with the claims, various opinions about Ukrainian law were submitted of various independent experts, and as such the defense had access to all necessary expertise to put up a proper defense. Now, besides, Pilatus also had ample time to put up a defense against these claims. With regard to the questions about the competence of the court and applicable law, he had 2 years, which is from March 2022, when your court indeed put these questions for the first time on the agenda. And with regard to the substance of the claims, they had 1 year, which is as of the time that we submitted these on the 13th of April last year. And I added a timeline to my notes, and you can see at a glance how much time the Defense Counsel has had in time to defend against these claims and the questions related to it. There's another element that should play a role in assessing admissibility, and that's the fact that when the prosecution of the defendants would not have taken place in the Netherlands but in Ukraine, that the relatives could have submitted a claim for damages in these proceedings. It follows from Article 1177 of the Civil Code of the Ukraine. And contrary to the Netherlands, there is not an opportunity in Ukraine for a criminal court to state that the claim for damages is not admissible. They must indeed assess them on substance. They cannot refer to a civil court. The decision to prosecute the defendants in the Netherlands should not be detrimental for the relatives, because that would be contrary directly against the European Victims' Rights Directive, which stipulates that member states must guarantee the right to make sure that there are compensations possible in the criminal proceedings from the perpetrator. Now, and indeed, the European Victims' Rights Directive states that if there is a national option to be able to assess that claim, and that brings me to the next argument, which is that that option for a civil court in Ukraine is not available in this respect. In case of non-admissibility, it's always automatically thought that it would be referred to a civil court as a standard sentence in a judgment. But two aspects are always forgotten, and the first is that a civil court, other than a criminal court, cannot impose an order to compensate damages, and that the relatives may not receive an option to recover damages. And the second reason, which pertains to this case, that the Dutch civil court does not have jurisdiction. Article 10 of the Dutch Code of Criminal Procedures does not grant jurisdiction for a civil court. You are back to your pleading notes. Yes, indeed, I am. Yes, it's paragraph 2.21. I had only a very brief sentence outside the notes. Now, the second reason that the second reason why it is urgent to indeed include the claim in these proceedings is that the Dutch civil court does not have jurisdiction, because Article 10 of the Dutch Code of Criminal Procedure does not grant jurisdiction to a civil court, and the only possible applicability rule for competence for a civil court is the forum necessitas clause of Article 9. Now, however, experts Van der Pas, Van der Hoek and Dieben did indeed remark that that clause is applied very restrictively, and it is therefore, we deem the opportunity very small that the Dutch civil court would indeed derive international competence with regard of jurisdiction with regard to the claims of the injured parties, and the likelihood that the relatives will be able to press charges in Russia or in the Ukraine is very limited, moreover in these conditions. In other words, the relatives have no other option to claim damages against the defendants than in these criminal proceedings. And finally, I promised you a more perspective from a more legal theory perspective. Now, in order to assess this, we asked your attention for the fact that the compensation is no longer a private law element in the criminal proceedings. For compensation and repair of distress are by now an independent sanction target. And René Kool has published in the Netherlands Law Journal about this, following her earlier publication in the Libre Morgan for Tineclair. And because it's so important, we have annexed it to our pleading notes. New is this idea, this concept of coherence between criminal law and the compensation. That's not new. As early as the 1990s, the Commissie 2 already stated that concurrence between sentence and compensation exists, and the Commission holds that the response to the offence may be expected to express that the injury to the interest of the victim has been addressed, and that is what the compensation survey believes should take place by compensation of damages. And it means that criminal law must be deemed to actually reduce distress by means of compensation of damages. And therefore, it must be assumed that the submitted claim for damages must be assessed on substance in the criminal proceedings. If this doesn't happen, and you can see that from scientific investigation, it may have an impact on the legitimacy of the criminal law case. And I do realize that I didn't mention the source for that scientific investigation, but you can see it in the earlier notes that we have quoted with regards to compensation of damages. Now, I return to my notes once again. The fact that the assessments of compensation is deemed so important in the criminal law case is related to the fact that recovery of damages after an offence has now become a public matter, because it is a suffering that is suffered after a criminal offence. Now, the meaning of assessing the claims of the relatives is important because the interests of the victim are acknowledged in it. And in other words, the victims can feel acknowledged when their claim is incorporated in the criminal proceedings and discussed on substance. This also implies that the contrary may happen when the claim is seen as a disproportionately taxing element. It may impact the feeling of acknowledgement. The admissibility of the relatives in their claims also expresses something about the extent to which the court acknowledges the harm inflicted by the offence. And let me conclude that part and now talk about the consequences of non-contestation in view of Article 149 and 150 of the Dutch Code of Criminal Procedure. Now, the defence that the claims are not admissible, what I've just discussed, cannot be considered as a contestation on substance, because indeed asserting and contesting are communicating vessels. The catch-all defense, the disproportionate taxing, cannot be considered as a contestation when compared to the very comprehensive substantiation, let alone as a sufficient contestation. In addition, the scope of the damage has been acknowledged by the defense, and this raises the question, what will be the consequences of non-contestation for the assessment of the claim? In the criminal adhesion proceedings, the rules of asserting and division of the burden of evidence apply in civil cases and not the minimum rules of the Code of Criminal Procedures, and also with regard to pain and suffering. Now, the question what the consequences are of non-contestation are established in Article 149, paragraph 1 of the second sentence, that the court must consider the facts that have been asserted by the one party and have not been contested or sufficiently contested by the other party, which must be understood as acknowledged by the other party and therefore must be considered established, after which the claim be allowed, unless the court deems it to be unfounded or unlawful. And this is in line with what the Supreme Court stated in the clarification ruling, and you see the quote in my notes. And with regard to the question whether the claim is unfounded or unlawful, there is a marginal ex officio test whether the claim is not contrary to objective law, which is public order and mandatory law. And as we, the Council of the Relatives, feel, that test, whether it is contrary to objective law, does not lead to a different conclusion than that you allow the claim. Another consequence of non-consultation is that the court has no discretion to base its decision on legal grounds or defences that may indeed have become apparent with regard to what has been revealed during the proceedings, but have not been based on the defence of the relevant party. As such, there can be no set-off when it was not invoked by the defendant. Now, the question, how does this relate to imposing a compensation order? The previous limitation from civil law do not apply. The level of the order to be imposed is reserved to the judge, but will, as a rule, will be closely related to the facts and circumstances on which the claim is based. And therefore it applies that these are not contested, and then it applies what I said before about the consequences of Article 149.
And that brings me to my third subject, which is the amount of moral damages. And a lot has been said about this already. What has been established on this subject by now? Well, first, it is indisputable and inarguable that moral damages were suffered. 105 relatives have not just said so in this court in September and November of last year, but they also showed it. The intense grief was tangible in this courtroom. Another 52 relatives have put their grief to paper, and those written victim impact statements have been submitted to the court as a book of grief on the 8th of December 2021, and they were added to the file. And in that way, for a little while, we shared in the last goodbye a mother said to her son, a father to his daughters, a brother to his brother or sister, and a grandfather to his grandson. We got to know the people who got into that Boeing to Kuala Lumpur on the 17th of July 2014 a little bit via these stories and photos that their loved ones shared with us. And they talked us through their lives and the meaning they had and still have in the lives of people they so suddenly left behind. And we were almost able to see their faces behind the windows of that Malaysian Boeing 777. And we visited the wreckage of the Boeing in Gilserijen in May of last year. So we saw with our own eyes that the suffering and the stress we heard about here in court was a direct consequence of causing MH17 to crash. That is the second established fact. The suffering of the relatives is indisputably direct damage as referenced in Article 51F and Article 361 of the Dutch Code of Criminal Procedure. The third established fact is that damage qualifies for compensation if the charges are declared proven, joint and several liability of the accused for the loss suffered by the relatives is a given. The applicable Ukrainian civil law determines that in that case the damage suffered by the relatives should be compensated, including moral damages. The fourth established fact is that damage is also established under Ukrainian law. It follows from International Private Law Article 15b of Rome II. So that claim should be assessed based on the standards and the legal framework applicable in Ukraine, as a Ukrainian criminal court would do it if the claim had been presented to them. And the heart of that assessment is that the court under Ukrainian law takes into account all the circumstances of the case and bases itself on the starting point of a reasonable, balanced and fair compensation. Ukrainian law doesn't impose any minimum or maximum on the compensation of moral damages, nor are there tables with categories or bandwidths that are available on the basis of which the amount of compensation for pain and suffering can simply be determined. That means that the assessment of compensation for pain and suffering under Ukrainian law is not simple. But that means the situation is quite similar to that in the Netherlands when it comes to assessing compensation for pain and suffering, because under Dutch law as well, that is a difficult assessment to make. And that assessment often leads to very different amounts being granted. Victim Support the Netherlands in 2019 drew the attention to the unacceptable differences in cases and even called them arbitrary. So if we were to present the question of the amount of damages to three different parties, we would get three different answers. The Relatives Council has based its claim on an amount that varies based on the family relationship and the living arrangements with the deceased, where the amounts claimed vary from 40,000 euros in the third category, 45,000 euros in the second category, and 50,000 euros in the first category. The Public Prosecution Service has argued that the basic amount that should be compensated is 20,000 euros. That is the fixed and capped amount that we have under Dutch law, the Emotional Damage Compensation Claims Act. Public Prosecution Service then feels it should be increased by 20,000 euros for the first category, meaning these relatives would receive compensation of 40,000 euros. For the second category, the Public Prosecution Service feels it should be 5,000 euros less, so that's 35,000, and then for the third category it should be 30,000. The defense has argued that any compensation is justified because of the undescribable nature of the consequences, and I think that is the only position where the Relatives Council and the defense agree. Because distress and money are quantities we cannot compare, it is always painful and uncomfortable to talk about converting distress into money, especially when a jurisdiction does not have a table or a bandwidth or fixed amounts. And then it makes sense that the first idea is to look at what we do in our own jurisdiction and to then transpose that to the other legal system. Public Prosecution Service found that firm ground by looking at the fixed amounts of the Emotional Damage Compensation Claims Act. So they used that fixed amount as a basic amount, and they then increased it to the aforementioned amounts. And as a thought experiment, that is certainly worthwhile. But upon closer consideration, that exercise leads to an assessment that is as random as the Public Prosecution Service has seen in Ukrainian case law, because why is that amount of 20,000 euros the minimum? Normally, in assessing compensation for pain and suffering, based on Article 6(106) of the Dutch Civil Code, there is no such minimum and no maximum either. And what is that increase proposed by the Public Prosecution Service of 20,000, 15,000 or 10,000 euros based on? So we think we are on firm ground by using the Dutch law as a basis, the Emotional Damage Compensation Claims Act, but upon further consideration, that assessment is as arbitrary as an assessment without bandwidths. Also, the Dutch Emotional Damage Compensation Claims Act is not intended to compensate all moral damages, contrary to Ukrainian law. That's an important distinction. So that this method of assessment is perceived as arbitrary is also clear from the reactions of incomprehension and sometimes outrage from the relatives when it came to this part of the public prosecutor's address. And let's not forget that Ukrainian law does not leave the Dutch courts entirely empty-handed when it comes to assessing compensation for pain and suffering. The assessment framework is clear. The assessment takes place with due regard for all circumstances of the case and with the starting points of a reasonable, balanced and fair compensation, and that assessment framework is in line with the principles of European tort law, which also use that starting point, that all circumstances of the case are decisive for determining the compensation for pain and suffering. I refer to that not because those principles are particularly relevant or form a framework for assessing the compensation, but just to show that Ukrainian law doesn't have an assessment framework that is very different when it comes to compensation for pain and suffering. In addition, the Ukrainian case law submitted by the Relatives Council is helpful. Of course, these cases are different when it comes to circumstances and amounts, and these judgments don't provide a very clear insight into what weight is granted to various loss factors, but that is not very different from Dutch case law. Certainly, in determining compensation for pain and suffering, it does not mean that the court goes back to the fixed amount of the Emotional Damage Compensation Claims Act and then increase them as he sees fit. Just like in Ukraine, they weigh all the various circumstances where they also look at amounts granted in similar cases, though they don't look at that exclusively. An analysis of recent Ukrainian legal decisions for cases where a loved one died because of a crime, and we've submitted this case law previously. If we look at that, we get a bandwidth of compensation of about 40,000 euros to over 100,000 euros. In the opinion of the Relatives Council, the Ukrainian case law offers clear and useful starting points for this court to assess moral damages. Though I will immediately note that neither Ukrainian nor Dutch law has cases that are comparable to the downing of MH17, and if we make a comparison with events that do have some similarities, meaning that there we are talking about civilian airplanes shot down by the military, then in the context of out-of-court or in-court settlements, significantly higher amounts were paid to relatives of victims. Higher amounts than currently being claimed. And I've listed 3 examples in my pleading notes where we're talking about millions of euros, many millions of euros often, that were paid to relatives. And if we then look at the amounts claimed in these proceedings, which vary from 40 to 50,000 euros, so not millions at all, and we look at the amounts that Ukrainian courts have granted the relatives of victims of crime, then in the amounts claimed in these proceedings, in light of the serious consequences, are certainly fair and balanced. And before I finish my statement, I would like to make a short remark about the starting date of the statutory interest and the compensation order. The Public Prosecution Service wrongly assumed a starting date of that statutory interest of the moment that the decision becomes final, but that is not quite in line with the starting date under Ukrainian law, where the interest starts accruing from the moment that the decision takes legal effect. And under Ukrainian law, if we look at the judgment in first instance, that is that takes legal effect from the moment that the appeal period has elapsed without being used, and then a judgment on appeal or appeal in cassation. Those decisions take legal effect from the date the judgment is rendered. So it's a slightly different moment than the date of the decision becoming final, which is what we use in the Netherlands. The Relatives Council therefore maintains its claim that the statutory interest should be granted over the entire amount of compensation from the date on which the appeal period lapses, in this case, or from the date where the Court of Appeal or the Supreme Court has given its judgment. With regards to the compensation order, the Relatives Council would again like to draw the Court's attention to the fact that the uncapped advance payment scheme does not apply if the Court only finds the charge of Article 168 of the Dutch Criminal Code proven. In Article 414, Paragraph 2 of the Enforcement of Criminal Law Decision Decree, murder and manslaughter are mentioned, but not Article 168 of the Dutch Criminal Code, which has been charged in this case. And we feel that's been an omission of the legislator, that they failed to mention that in the uncapped advance payment scheme. But it means that if the court only finds the charge of Article 168 proven, then the amount the relatives will receive when their claims are granted will only be 5,000 euros, and we certainly did want to mention that aspect of it. And that brings me to the last few things I want to say. So the multi-annual agenda for victim support puts it very nicely. It's a document of the Ministry of Justice and Security. They want to do justice to the victims of crime, but in this context, in this case, what does that mean, to do justice to the victims? It certainly means that criminal proceedings takes place where the accused stand trial and proceedings to which the relatives of the victims have been able to contribute. And these important steps on the road to justice have already been taken. It also means that we get a court decision with an independent and authoritative judgment of the sub-questions identified by the court, and the relatives are aware that the court cannot write history. With an extensive explanation of the reasons behind the justice, especially when it comes to sub-questions 1 and 2, can substantially contribute to a feeling of justice. And doing justice to the victims also means compensation and redress. I would again like to note that not all relatives have been able to make a claim for emotional damage in these proceedings, because Ukrainian, by the way, also Dutch law does not entitle them to compensation. We've drawn your attention to this previously. For example, the position of the 250 persons who, because of the downing of MH17, lost a brother or a sister. Their suffering is not any less great, and the consequences of that loss are not any less serious for them, but still, in these proceedings, they were unable to make a claim. For the relatives that do have a claim for compensation, we again ask the court to look at these claims for compensation on the merits. And weighing pain and suffering is an almost impossible thing to do. I've said this before. The grief, the damage will never be balanced by a financial compensation, no matter how much money you put in the scales. But a compensation will lead to a certain degree of settlement, and the amount of that compensation is in part determined by the scales that are used. And in this case, it is not the scales of the merchant with a pound more here, an ounce less there, that would lead to a fair and just compensation. Of course, that doesn't mean that the damage and the scope of it should not be adequately substantiated, but if that substantiation is sufficient, then what we'll need in this special and complex case are scales which, from the head, but with the heart, provide a balanced and fair compensation. Thank you for that statement. We'll now continue with the reply of the Public Prosecution Service. It's 11:20. I propose we take a break until 11:45 and that we continue then. That should be fine. Just so you know, we have two pretty cohesive blocks of between an hour and 15 minutes, an hour and a half, and if we continue to at 11:45, we would be able to have lunch at 1:15, somewhere between 1 and 1:15. Well, I think then that's the way to go. So we're going to have a break until 11:45.